Thank you everyone for joining today's panel discussion on the Code of Conduct for Building Surveyors. Before I start, I'd just like to acknowledge the traditional owners of the lands on which we gathered and pay respect to their elders, both past and present. I'd also like to welcome today's fellow panellist members, Bronwyn Weir from Weir Legal. Bron, thanks for attending. Wayne Liddy, Australian Institute of Building Surveyors, and Peter Jolly, Victorian Municipal Building Surveyors Group. So we've got a good spread of knowledge. Obviously, Bronwyn's been heavily involved in the development of reforms in the Australian regulatory environment. One of those was obviously the Code of Conduct in the Sheargold New report. So it's great to have Bronwyn along. So the Code of Conduct. We're often asked why are we actually implementing a Code of Conduct, and it's an important document. It's important to have these sort of documents not only for building surveyors but for other practitioners within our industry. There are many reasons why Code of Conduct is important. It's actually part of the proposed national framework being developed by ABCB, the Building Confidence Report team, who in turn have been tasked with implementing recommendations from the Sheargold Weir report, with recommendation 10 being the Code of Conduct for Building Surveyors. As part of the reviews and looking into the system and where the system could be improved, the integrity of building surveyors has been questioned. And this is a particular issue where, as we have in Australia, we've got a privatised system. So I think code really strengthens our position around how we should behave and what the expectations should be of us as a profession. So it provides that clarity and removes some of that disparity that we have amongst different practitioners and the expectations that we actually receive from other practitioners within the industry. Codes of conduct can be an effective means of documenting the clear standards of behaviour and expectations for us as professionals who have statutory responsibilities. I think the codes are particularly important for building surveyors, where we've got that statutory responsibility. We're fairly unique compared to a lot of the other practitioners in the building industry. The codes of conduct provide a reference against which auditing can be carried out and disciplinary action taken where the code's not met. And so it provides that, once again, a bit more guidance above the Act and the regulations. So obviously the Act and regulations dictate the legal requirement, and the code is another tool that assists us in interpreting our role within that legislative framework. It really helps the intent and application of the legislation, and I'm hoping that it will create a more level playing field for us as building surveyors. That I do see there's a large range of understanding of what the role of the building surveyor should be, what they can and can't do. It creates a lot of frustration, not only within the building surveying profession, but via other professions that interact with the building surveying profession. So it's not a good outcome overall. That it's important that we're all providing a similar level of service, and then that introduces a bit more confidence in the market around our capabilities and our respect within the industry. So the Building Act and Regs provide for a code of conduct and its enforcement within Victoria. Victoria was one of the last states to actually implement a code for building surveyors, but we're the first to actually implement one in line with the Sheargold Weir recommendations. So the decision to create a code of conduct was driven to a degree by the national framework direction. We've been asked why we've moved so early rather than actually wait for ABCB, and I think it's because of the importance that we see a code plays within our building industry, that to wait for the ABCB to formulate their code and then implement it could mean another couple of years in the process. The code is really, we believe, an important piece in restoring confidence in the industry, and then hence, hopefully, restoring confidence of the insurance market and providing some more stability in that market. So we've worked very closely with ABCB, very conscious that that is a risk for us, that we are committed to the national approach in trying to align with the national provisions elsewhere within Australia. So we've been liaising closely with ABCB in the development of our code, and watching closely as they evolve theirs, to sort of pick up any changes that we may need to consider down the track. So it will be something that we will be reviewing. Hopefully there won't be any change, but there may be some change that we need to consider to align our code with the national framework once that's defined. I think the important thing out of a code of conduct, or for us as building surveyors as a profession, the primary obligation for us is ensuring compliance with legislation, and importantly, to act in the public interest. So I think, you know, the real focus for me in the code of conduct is the public interest factor, that at all times we should be focusing on public interest. We need to remain independent and impartial. Private building surveyors, clients are not just the people that pay them, but the broader community itself, that we really hold a responsible position in society, that we are the custodians of safe buildings, and we need to be focused on that at all times. That you know, there are lots of external pressures as a private building surveyor. Even as a public building surveyor, there's those pressures. So it's a complex world that we operate in, and a complex environment. And so it is even more challenging to remain focused on those goals of ensuring public interest as the outcome, which may not always align with your direct clients' requirements. So on that slide at the moment, there's basically the 8 principles that we've created within the Code of Conduct. So these are the core principles, and under those we've got a set of rules that are hopefully assisting with an understanding of how to interpret those principles and how to apply those principles in your day-to-day operations. They're aligned around the principles that came out of the Sheer Gold Weir report. So, and hopefully today we'll sort of explore some of those. We've got a number of questions that you all kindly submitted as part of the registration process for this event. So we've got lots of great questions. I think it's a learning process for all of us. So even though we've created the code, it is new for us to apply. We would hope that it's clear and concise, but like any document, it's going to have its interpretations, and we're going to learn as we move through it, and try and determine, you know, where the line is for a lot of these provisions. So the intent is that our initial focus will be on education. So we're running a number of presentations and exercises, not only to building surveyors, but to the broader industry, to make them aware of the code and what they should be expecting from building surveyors, as far as not expecting the things that they would normally expect from them, you know, design involvement and those sort of things that some may be used to in the past. So it's really trying to highlight to them that they may experience some changes in the building surveying profession out of the introduction of this code, and to be understanding as to why that's actually occurring, and supportive of that process. So from our perspective, we are having that education focus, that enforcement is not the high priority for us in the first period of the introduction. We'll be trying to assess compliance with the code as we move through, and how we might sort of enforce that in later stages as we become more confident in the settings that we've got in, and as you all become more familiar with the code of conduct and how it operates. Having said that, obviously, if there are breaches that are of concern, then we still hold the ability to undertake required disciplinary action. As far as the code itself, we've consulted, as I said, closely with a number of parties, not only ABCB, but stakeholders, AIBS, HIA, MBAV, architects, engineers, right across the spectrum, government, to really get feedback from all of those parties, in addition to public consultation. So as far as I understand, it's one of the biggest consultation processes the VBA has been through on a document. We had a lot of input, which was encouraging. I think there's a lot of interest in this space. And we got some great feedback that we've considered and incorporated within the code. And general feedback has been good with the code. So I think now the challenge is getting it to actually work and do the job that we were hoping that it would do within the building surveying profession. So we might now move on to the questions part of the session. So I might hand to Bronwyn, and we can maybe move on to the next slide and get things underway. So welcome, Bronwyn.
Thank you, Andrew. So the way that we're going to move forward is to put up on the screen for you questions that were provided in advance, and the panel will work through those. But there's also a Q&A facility for you to put questions in, which we will come to once we get through the dozen or so questions on these slides and start to take questions live from the audience of over 300 participants who have logged in to view the event. So think up your questions, put them in the Q&A, but in the meantime, we have some here that might already answer some of the issues that you'd like discussed today. So the first question, Andrew, I'll ask you to answer this one, is will similar codes of conduct be introduced for other professions?
Thanks, Bronwyn. Yes, they will. So I think this is the first one. I think it was identified, building surveyors were identified as a priority in both the Shegold Weir and the ABCB framework documentation. So we've developed building surveyors as the first practitioner set that we're looking at, but we're now moving on to other practitioners. So we're currently reviewing builders and engineers. So engineers have proved a little bit complex in that the new registration format for engineers is going through CAV rather than through VBA. So we don't have as much direct line of sight or control over that, but we're working with CAV to ensure that we've got similar principles and guiding rules underneath those that will hopefully create the consistency that we're looking for across all the various practitioners.
Yeah, and I guess the other point about that, Andrew, is that the Building Act provides for codes of conduct for any registered practitioner group. So the VBA certainly has the ability to create and gazette codes across all of the practitioner groups. And as you've said, that's the intention. What's being done to educate other industry practitioners about the code?
Yeah, so we've got a fairly comprehensive social media campaign at the moment that's trying to get the awareness out there. So part of the challenge is actually understanding that there is a code of conduct, and then the next challenge is understanding what that actually means for them and for building surveyors. So we're holding a number of presentations. I've got another one tomorrow with legal fraternity and a whole range of practitioners within the industry. We've got another one in a few weeks' time with engineers. We'll be looking at engaging with architects and builders as well. So we've sort of picked up that message loud and clear from building surveyors in general, the concern that this is all focusing on building surveyors, and that I totally agree, we're one piece of the puzzle, that we've got lots of other practitioners in the space, and it's the code is not only looking at the behaviours of building surveyors, it's the people they interact with. It's setting their levels of expected interaction with building surveyors. So, you know, I know the response will be, well, they're not subject to the disciplinary action under the code, but it provides a bit more rigour. It provides a bit more of focus for building surveyors, that they've actually got a document that they can actually refer back to. And when you're getting that message back from a client that other building surveyors do it this way, you've actually got something that can support you, that you can actually say, well, they shouldn't be doing that way because this is what the code says. This defines what can be and can't be done. So, so yes, definitely an important piece of our work is trying to communicate it to other industry practitioners to get an understanding of what you know, their interaction should be with building surveyors, and how they should not look at making them step over the line in regards to the code of conduct.
Yeah, and I guess the other important thing to note about that is, regardless of how many seminars you hold, you're not going to be able to directly speak with every industry practitioner, and there's going to be some level of work to be done by the building surveyors themselves, as you say, to point these things out to their clients and direct them to the code, particularly in the early phases next year as the code starts to take effect, and help educate more broadly. But it sounds as though the BBA will be doing what it can in terms of those industry educational sessions. Third question, why has the Code of Conduct gone beyond establishing a set of ethics, principles and values to include operational and business management principles? Andrew?
Yeah, so I think you know, my understanding of a code of ethics is that it's higher level, it's more values-based, generally a shorter document. So we didn't think that was of much value as a code of conduct, that we really needed a code of conduct which actually provided more guidance around how you might interpret those principles and apply them. So it was trying to be example based and providing more clarity around how you would apply it on a day-to-day basis. So it obviously still includes those principles, those high-level values that we need to display as professionals. But it goes further, and and I think, you know, part of the question and the the concern is that we've included some of the provisions that are already within the Act and regulations, and that's really, you know, highlighting things that are aligned with what's within the Act and regulations. Shouldn't need to be repeated, but they're things that we have seen within industry that are still being either misinterpreted or misapplied. So it's trying to provide that additional clarity, not only for building surveyors once again, but for the broader industry around what the expectations are, and then hopefully that will mean more consistent outcomes for building surveyors in the way they deliver their services.
I think the other thing I'd add to that is that in terms of the length of the code and the formatting of it, it is consistent with the national model code, which there was a discussion paper on. The final version's not been released. And also in New South Wales, about 6 or 7 weeks ago, there was a new code of practice, they've called it, released, which is about 3 times the size of the Victorian code and does go into very sort of mechanical detail around the practice of building surveying and the expectations of government in New South Wales. So it is certainly something that across Australia, these codes, the approach being taken is that they are more detailed. They do go into business management principles as well as those ethical obligations, partly because that reflects the role of the building surveyor. And so things like complaints management processes and obligations around documentation have been included because they're central to the proper delivery of functions of the building surveyor. We can move to the next slide. So this slide is about principle that's in 4.2.2 of the code about this interaction between design and the independent assessment of design, which is perhaps, you know, the most talked about part of this. And from my perspective, having made the recommendation for a code of conduct for building surveyors across Australia, this is one of the reasons why, because of this complete, I guess, difference of opinion about the extent to which a building surveyor can be involved in design. So the fact that everybody is talking about it and trying to understand it and hopefully create some consistency around what is expected in relation to this independent role of the statutory building surveyor, this is, it's not surprising that there are lots of questions about that. Wayne, I'm going to throw to you with the first one. How should this be interpreted? You're on mute. Thanks.
Not anymore. Look, Bronwyn, I do think there will certainly need to be a change in business practices for some. But when I say some, I'm talking about the minority. And if we're talking about that, what we once called the perceived conflict of interest, we know that it's inherent. I think we've got to start to own the problems that are in the industry and push forward, and it's up to industry to lead the way out of the problems we're seeing at the moment. Part of what I see is this issue of building surveyors being involved in design. It starts with, for me, it starts with the procurement process. And Andrew's already touched on education of industry in his opening comments. And I think we start from education of the industry. There are parties in the supply chain that are unregulated, and I'll talk about project managers, and I'm not sure how the Victorian Building Authority is going to educate parties, because I can't call them practitioners, they don't have a registration category, but we've got parties in the supply chain who are not registered, and therefore there won't be any oversight over their functions. And then we get to procurement, but there's also emphasis on the building surveyor in this instance. So if you're going to provide a fee proposal, you've got to be very, very mindful of what you provide in that fee proposal. And if you are going to clearly articulate in those fee proposals that you will get involved in design, you will provide value management solutions, and you will propose alternatives to the deemed to satisfy provisions, i.e. identify performance solutions, then clearly that is a conflict of interest. Andrew did mention earlier that many of these aspects are within the current Building Act. Sure, we don't need to see a lot of change, but unfortunately, because there's been that minority within the industry who have continued on with poor practices, the unfortunate result of that is that we do have this very, very long-winded code of conduct. There will be a need for many to change their business practices to look at the way a project is rolled out. But that also starts with builders, and we've got to look at the appointment process, whether it be domestic builders or whether it's the tier 1s, 2s and 3s, and we're looking at the D&C process. I know I've sort of veered off a little, Bronwyn, but I think we've really got to start with the procurement and the appointment process to look at the questions that are going to be asked today and how we answer the questions that will no doubt be thrown at the VBA post this today's forum.
Okay, thanks, Wayne. Did you want to say anything about how to respond to non-compliances in design in principle?
Okay, yeah, certainly, Bronwyn. I had this discussion earlier today. I'm of the view that the relevant building surveyor must be in a design meeting. They must sit at the table, because ultimately the relevant building surveyor is the authority having jurisdiction, is the approval authority. decisions on design should not be made and accepted by a design team in the absence of the relevant building surveyor having input into the ultimate design solution. If there is a proposed performance solution, if there's a performance solution proposed on any aspect of the design, it must ultimately be approved and determined by the relevant building surveyor. So decisions being made in isolation of the relevant building surveyor should not occur. And I think relevant building surveyors must identify and understand that ultimately they are the approval authority for a building. And any decisions that are made by the design team should consider whether there will be ultimate approval by the relevant building surveyor. Now, there's a big difference between the relevant building surveyor providing design advice, as in identifying performance solutions and nominating how they might be resolved. This is where building surveyors tend to get themselves in the poo, because we are seeing that building surveyors are being used as the convenient scapegoat for every problem that has arisen in the building industry. And we really need to start demarcating our role to what it should be as a relevant building surveyor and start putting some responsibility and onus on those who are actually charged with the design of the building, and also those who are charged with the build of the building. It shouldn't be the building surveyor's role, and building surveyors need to start saying no and articulating what their role is. And this is where the Code of Conduct will assist, as it's a document that can be forwarded back to the design team and the builder as to what your role actually is.
Peter, do you have any comments on that? And then I'll come to you, Andrew, on any of those three questions there about the participation in design or the role of the relevant building surveyor in report and consent applications.
So I agree with Wayne that if you read the code the way it's presented, it tells the building surveyor to be conservative in their determination of their involvement in these things. So clearly the relevant building surveyor will have a role in making decisions and giving advice about designs that don't comply and explaining why they've formed that opinion, and they'll be giving advice about what alternative design proposals would be acceptable and considered compliance. But the code, in my view, provides good guidance about how to be reserved in deciding the level of that involvement, and it's about not being part of the design team. So you're not formulating the designs. You're providing advice about compliance and what you as the RBS consider to be compliant or non-compliant, and it can even involve providing advice, in my view, about what the alternatives are in terms of access to the Building Appeals Board and things like that. But being involved in the formulation of design, I think the code's pretty clear. It's not the role of the RBS, it's the role of another building surveyor to provide that service.
Andrew.
Yeah, and I think it's probably one of the most difficult parts of a building surveyor position in trying to draw that line, because I think you've got the two opposite ends, where you've either got full design involvement, so you're being creative, you're actually with the design team providing alternatives, options, solutions, versus at the other end of the spectrum where you're only looking at the design once it's all completed, 100% documentation. You pick up that, you do a compliance assessment, and you dead back to the design team to say, well, these are the things that you've got wrong, try again. The issue with that hard and fast end is that it's not very efficient, so that you get the issues that the design team may go off, invest a lot of time in design and documentation to find that the building surveyor has major issues, and then you've got to redesign. So it's how you get the balance of the best of both worlds by allowing some level of design input. So it is sort of routine in general. It's guiding. It's what I like to think of it is that you're setting the goalposts. You're not kicking the goals. You're actually putting the goalposts up as to what you think the team needs to achieve to actually get the outcome that you need from a compliance perspective, but you're not actually giving them the solution, or so you're saying egress distance is more than 20 metres, and so you're still pointing them in the right direction. And so there is that need for some involvement during the process, and I think I'll probably sort of point everyone to the ABCB guidance documents on performance solutions as well. They're quite good. They actually look at this to a degree around the independence required by the building surveyor, not to be involved in the design process, but the need for them to be involved as a stakeholder when you're actually formulating the performance solution. So they are sitting there, they're confirming what the acceptance criteria are, what assessment methods might be approved to actually formulate that performance solution. And so that gives some certainty to the design team when they're actually then progressing into more detailed design around what the outcome should be. And the principle here is that if you're involved too early and too deeply in the design, then when you actually sit down to do your full review, that you may find that you've given the wrong advice right at the beginning of the process. So there's a conflict, you're in effect doing the design and approving the design, which is not the way the system is meant to work. It's meant to be a third-party independent review. But it's that balance of how do you achieve that while you're still providing some of that design advice in the process. So I think this is one that we will still struggle with occasionally. There'll be issues where what is too much advice, but I'm hoping we'll cut out that far end sort of full-on design advice. And I think it really brings into play the building surveying consultant too, where we've got highly complex projects. There's probably the need for a building surveyor to come in and provide that we are working in a very complex building code environment, performance solutions, that the design teams will quite often struggle with the regulatory compliance provisions, and so there may be a need for that expert input and creative input to sort of explore the options and the design opportunities that they might have through performance.
Yeah, and I think the other point that I'd make here is that the Code of Conduct recommendation in the Building Confidence Report is one of 24 recommendations. There is a recognition in this, trying to address this issue that currently design practitioners don't understand the NCC as well as they should. Now that I think is a failing of the content of the qualifications for design practitioners, architects, draftees, and potentially even engineers. But the point is, it's also, I think, been exacerbated by the business practices of the private building surveyor in wanting to provide a service of really filling that gap on NCC compliance into the design, and in doing so, compromising their independence as the statutory relevant building surveyor in the Victorian context. So there's no doubt that, and in fact, the question here from Lisa is, can we provide the clauses and parts from the NCC to which they must provide a solution, or do we have to stay mute? And in saying this, I think this is where you find a hole in some designers' knowledge of what is expected in their designs. So do the BBA need to educate designers so they actually understand what the performance provisions are? Well, I'm not sure that it's only the BBA's role to do that, but there are a number of other recommendations in the Building Confidence Report that go to this issue, including the recommendation that designers have to make a declaration that their design is compliant, and the intention behind that is that they must actually go away and understand the code and produce documentation that is complete with compliance information in it, rather than hand it over and collaborate with the building surveyor who's going to ultimately approve that design on those finer NCC compliance issues. So I'm sure there's a role for the VBA, but there's a broader issue about the knowledge and competency of designers that really is trying to be addressed with this in order to re-enliven that need for independence. So I think that's a great question from Lisa to really highlight that point. The code itself says that you can identify which performance requirements might be relevant. You can talk about the range of assessment methods that are available. So you can give that sort of advice, but you can't suggest what the performance solution might look like in terms of the design elements of that solution. The last question on this slide was about report and consent, and Peter, you're also a Building Appeals Board member, and you might want to comment on this because the Building Appeals Board's had a fairly strong view for a long time that the relevant building surveyor shouldn't attend on behalf of owners when report and consent decisions are under appeal. And so really what's in the Code of Conduct is consistent with that position that the Building Practitioners Board has taken for some time, and that is again, that goes to the impartial position that a building surveyor should be taking in relation to report and consent. Peter?
Yes, so I think it's important that the relevant building surveyor is impartial and remote from the design and the formulation of the design. So people will engage other building professionals, architects, draftspeople, other building surveyors to assist them with these sorts of arguments, which are essentially, formulating an argument to promote an alternative to the citing provisions in Part 5. It shouldn't be a part of the function of the relevant building surveyor who's essentially involved in the assessment of an application for building permit and the issue of one in an independent manner. And their role really is to administer and enforce compliance, not to participate in the formulation of design proposals. And I think it would be difficult to have 4.2.2 there if you allowed this to be an exception. So I think it's consistent with the principles of the code.
Yep, great. Next slide, please. So these next series of questions in the slide is in relation to paragraph 3.2 of the code, which is about ensuring that any reports that you rely on where you're outside of your experience or expertise, that you rely on them independently, and that the person who provides those reports has appropriate qualifications. So the question here is the RBS required to check the suitability of the other practitioner that's providing that independent certificate or other report that you're going to rely on? And I'll ask Wayne to answer this one.
Yeah, thanks, Bronwyn. I'd probably show my age here and refer many to having a good read of the unfortunate case of Toomey versus Scalaro Concrete Constructions and the commentary around good faith and what is a good faith test. We often see in industry the Reg 126 is accepted in blind faith, not good faith. It's not, this is not new news, it's old news that if you are going to ask the courts for immunity under the 238 provisions by accepting a 126, then you must show, if you are going to request immunity or fight for immunity, that you have accepted that 126 or certainly design from someone in good faith by assessing and checking. You are not commenting on someone's qualification. So if someone's an engineer and they are qualified and a registered engineer, you are not commenting or questioning their qualification. However, a CV to determine whether they are competent in designing or they have a history in designing the relevant aspect that they are designing for that project is paramount. And I think that message is starting to get through. With many parts of this conundrum, we have got an industry where performance is so widely misunderstood that unfortunately building surveyors are forced to get involved in the design to achieve an outcome that would otherwise not be there. And that also relates to the report and consent process as we talk about Regulation 129 report and consent applications to the brigade. It's they're things that building surveyors shouldn't be doing, but unfortunately, due to a lack of understanding by the design team, building surveyors have had to get involved. I took the opportunity to just go off train a little bit there, Bronwyn.
That's all right. I'm going to give the next question to Andrew, which is around performance solutions being prepared by consultants who aren't registered building practitioners. And, is there a requirement that they must be, and that the RBS can only accept reports from registered building practitioners? Andrew, do you want to take that one, or do you want me to? You're on mute.
You can start if you like, Ron.
Okay, so there are certainly disciplines that have developed in relation to these areas where people have quite a bit of expertise, but they are ordinarily registered in one category or another. So it would probably not be completely unusual, but not that common that you'd be asked to, well, hopefully, accept reports from people who aren't registered practitioners. As far as the Act goes, it's really only around fire safety, where there are those obligations to ensure certain requirements are met. But having said that, draftspeople, architects, preparing and conducting design really should be registered. So I'd say, correct me if I'm wrong, but it should be unusual for you to be asked to receive reports from unregistered people. And I would have thought that in most cases, it wouldn't be appropriate to accept them, but there might be exceptions. The Act doesn't expressly rule it out. Andrew?
Yeah, no, I agree. I think, I think as we move into sort of the further registration of different practitioners as well, I think it will sort of resolve itself to a degree. So there are practitioners that aren't registered that may have capabilities and expertise in this space, but it does put a lot more onus then on the RBS when they're actually making that assessment as to whether that information is correct or otherwise. So it must be always remembered that the RBS does have that final responsibility. So even if it is a fully qualified registered practitioner, you still need to be having a look at the report and forming an opinion as to whether the justifications are appropriate in that performance solution, and that any conditions or assumptions have actually been included in the final design documentation, which unfortunately is not our experience with some of the stuff that we've audited. That there does seem to be some that will accept a report on face value and potentially not even consider what's in it, because a lot of the conditions or assumptions that were included in the report haven't actually been reflected in the permit documentation. So that's a massive issue when we're moving forward. So it's that whole aspect is very important, that the RBS really needs to have that overall appreciation of a project and really sort of pulls it together at that permit approval stage.
We can move on to the next slide. This one's about payment of fees, and there's also been some questions coming through the Q&A around payment of fees. So the first question, what is the impact of project variations and associated professional fees on compliance with the Act and the Code? Wayne, would you like to have a crack at this one?
Yeah, it's an interesting one, Bronwyn, because I've seen for many, many years on the bottom of a building surveyor's request for appointment or on a fee proposal, there's a standard line, pursuant to Schedule 2 of the Building Act, fees to be paid up front or part thereof. I think, and we've got to be very clear that the legislation says a fee, it doesn't say the whole fee, but in determining what fee, and let's be honest, a builder won't start a building without taking a deposit. An architect won't take a commission without accepting a deposit. So, and what we do see is that buildings will progress to a certain point where the fee is exhausted, and then unfortunately, if something goes amiss with a building surveyor, there are not enough fees left in that kitty to complete the job. So we've got to be really mindful of it. In relation to more specifically the question, if it is clearly articulated in the appointment document or the fee proposal about the structure of the fees, whether it is the whole fee up front or it is a portion of the fee up front and the remainder of it is collected or invoiced along the way, I think that's fine. It's got to be clearly articulated though, and this is the reason why we need I actually think for a statutory role there should be a legislated terms of appointment for the statutory authority. But in the absence of that, a clear fee proposal that articulates what fees are relevant, when they're required to be paid. So then if there is a variation or there is additional fees for whatever purpose, then they can be legally requested and invoiced to the client. The issue we see is that there are occupancy permits and certificate of final inspections certificates being withheld because fees haven't been paid. So I think that's an issue that the industry needs to get their mind around and ensure that the project, and it's probably more relevant to larger projects, but they're appropriately invoiced and invoiced early enough leading up to that final execution of either an OP or a CFI. Just on fees, and it's surprising that we still see that the BAM system was introduced to take the levies away from the working capital of the building surveyor, which AIBS certainly supported and drove that piece of legislation. But unfortunately, we're still seeing part of industry still paying building permit levies on behalf of the applicant. And unfortunately, those applicants are generally the builder. As I said at the start of the day, building surveyors have to take some responsibility as part of industry to lead their way out of the problems that can arise and we have seen arise. But back to your question, I think as long as you're clear, open and transparent and forms part of your fee proposal and the terms of appointment, there is no reason why you cannot invoice along the way for any additional works.
Yeah, I would agree with you there, Wayne. And I think what we need to understand is there's really two ways to manage your fees. One is through your engagement agreement, and you can arrange for fee payments through that agreement as negotiated with the owner. But the other is to remember that Schedule 2 is in the Act, which talks about the process for applying for permits, and that includes both building and occupancy permit applications. And what it says in Schedule 1 is that the application for the permit, so this is either the building permit or the occupancy permit, must be accompanied by a range of things, including the fees as determined by the relevant building surveyor. So the Act actually gives you the opportunity at those 2 points in the process to require the payment of fees with the application. Now, if you're at the end of a process and there are outstanding fees from inspections or from changes, variations to permits and other work that you've done, which you're entitled to recover because of your agreement that you have with the client about those increases in fees and when they can occur, you can render that invoice and require payment to be made with the application for the occupancy permit. And if you do that, you know, you don't even need to consider the application until those fees are paid, because Schedule 2 says that the application must be accompanied by fees as determined. So the Act does give you a couple of levers there with the issuing of permits or the applications for those, but that's not the full story, and you do need to have a clear terms of engagement and clearly articulate when you might charge additional fees. You can't just come along at OP stage and say you're going to charge an extra $2,000 for stuff that was never ever envisaged or set out in your agreement with the client. That's not what I'm saying, but I am saying that the Act does provide those couple of points of where you can require payment with those applications if so determined. I'll move on to the next slide. And this one's about 3.7, which talks about having effective procedures in place to ensure the completion of your work in the case of an inability to practice. So how should this be managed? Peter, Jolly, do you want to have a go at this? People who are needing to or unexpectedly become ill, pass away, what sort of state should their records be in, and how do you see this obligation playing out?
So it's a very interesting question, actually, Bronwyn, because it's my understanding that the way the Act is written in terms of Section 30 and Section 73, the documents that accompany an application for building permit, for example, must be lodged with the council. So, but what happens in practice is that only the documents that are issued with the permit get lodged with councils. Now, that's all well and good, but when things go wrong, then the council's not necessarily holding all the documents that may be useful to pass on to the VBA, for example, where they've been made a decision to appoint a manager to the business in the case of death or disappearance, kidnapped by aliens, as I often say. I think it's important that as a first principle, building surveyors should be making sure that all the documents that are relevant to the application are lodged with the council as the record keeper. And that would be of assistance in the event that they can't continue to practice. But also, I think it's important that building surveyors have very good record keeping systems and possibly need to put in place legal arrangements so that in the event of inability to practice, that someone else is possibly their lawyer or their accountant is in a position to make sure there's a smooth transition of all the records, including the inspection records and the approval records and whatnot, because many's the time we've seen at Hume City Council anyway, where building surveyors cease practicing and owners are banging on the counter wanting us to take over the file. Getting records is nigh on impossible in some cases, and it makes it a nightmare for the consumer, being the person who's engaged the private building surveyor in the first instance. So I think it's an area that the VBA and DELP need to reconsider in terms of tightening up this area, because it's not ideal for building surveyors or consumers of building surveying services. But I would suggest that in the first instance, building surveyors make sure all the documents lodged with applications for permits get given to the council. It would take a lot of pressure off them in the event that they have to, the doors of the business are closed for unforeseen circumstances.
And another question that's coming through, a couple of questions on the chat, which again, you might be best placed to answer, Peter, about the role of a private building surveyor in relation to assisting an owner with a building notice, for example. So if I'll give you a scenario, perhaps illegal building work, the owner's issued with a notice asking them to show cause why they shouldn't demolish, and that commences a process where they get a consultant in that looks at whether or not the work complies, what rectification might be required as part of the response to the building notice. And it turns out that they then need a building permit to do whatever rectification works are required to bring the works into compliance. And can that building surveyor who's given that consultancy advice and helped with the show cause response then become the relevant building surveyor?
Well, I think it's the same as what we've already discussed here. If a private building surveyor has been engaged to assist with a design brief for remedial works to remedy non-compliance that relates to illegal building work, then I don't think they can actually become the relevant building surveyor because they've participated in the design. It does happen where building work is constructed without a permit, and despite the absence of the permit, the building work, for all intents and purposes, turns out to be relatively compliant, that a private building surveyor might give a package of certification to the MBS of the council that the MBS can rely on, because an MBS who's issued a building notice or a building order is an RBS, and so the MBS could rely on a package of certification. But if it turns out that building work is required, alterations are necessary to resolve the non-compliance, and a building permit's necessary, and I suppose your feedback on this, Bronwyn, would be useful, but I think it's no different to what we've already discussed in terms of if you're involved in the formulation of the documentation of design solutions to fix up the non-compliance, and that documentation is to form part of an application for building permit, I don't see how the same building surveyor can issue the building permit.
I think the difference we've got here, Peter, is that you've got an MBS involved who's issued a show cause notice, who's looking at the response to that, and ultimately is going to potentially issue an order for that work to be carried out. So you do have that independent MBS involved in the enforcement, but there may well be circumstances where the nature of the work that's required is much more detailed, and you're sort of then treading into that potential line of lack of independence. But so I do think it might be a little bit case by case. I think sometimes in these scenarios the work required is fairly simple, and it might be to do with DTS compliance rather than necessarily performance solutions, and so it probably is less of an issue. So
no, I'd agree with you there, and if the role of that private building surveyor is simply pointing out the non-compliances for a draftsperson or an architect to document, an engineer to respond to, well, they're probably doing something very similar to what they do in assessing an application for building permit, aren't they?
yes,
It's the formulation of design solutions that's the difference, isn't it?
absolutely. So I would sort of say I think it depends, but potentially you could be crossing that line. But having the MBS in that process does help to, have a third, that MBS actually being the one to determine whether or not the proposal is suitable. But I can see situations where it could become a problem. And none of these things are black and white, unfortunately, which you might all say is frustrating, but I think that's part of your daily role, right? Nothing's black and white. I'm looking at some of the sorry, Peter.
That's all right. No, I was just going to say I agree with you there. Yes.
Yeah. Looking at some of the questions here, we've had a few people respond, I guess, to the question we discussed earlier about relying on performance solutions from unregistered practitioners, so access consultants, for example, or DDA consultants, and saying that they're not registered, so how could you accept a performance solution from them? To me, I wouldn't know that they're not always not registered. I think some of these people have been building surveyors who've become specialised in these areas. But yes, as I said, I think there's certainly potential that they're not. And I do think that the Act is not as clear as it it could be. I certainly know that under the work that's being done at the national level with the National Registration Framework and the other recommendations that are being implemented, it's envisaged that ultimately under the national approach, you would only be able to prepare a performance solution if you hold a category of registration of some sort. And so the national framework is intended to set that up, and then it'll be up to states and territories whether they take up that position. The Building Confidence Report did say that only registered practitioners should prepare performance solutions. The Victorian scheme isn't quite there yet. And so I certainly wouldn't say to you today, you can't accept a performance solution from somebody who doesn't hold registration as a practitioner. But I do think, as noted by Andrew before, that you need to be more careful about doing that and making sure that they do have the relevant skills and experience to offer that performance solution. Be quite vigilant about that. But the ideal position would be that we would have all of those practitioner groups registered, which is, I think, more of a longer term goal.
Yeah, agreed, Bronwyn. I think that was my point previously, that I think you do have that additional risk if you're relying on or reviewing a non-registered practitioners' work, but we do have that issue currently where there are a number of practitioners that aren't necessarily registered. They may have other qualifications, and so then it, unfortunately lies with the building surveyor to determine they've got that expertise available, and really requires them to sort of go through and vet the outcome, that they're comfortable with that.
I've got a question here on the screen from Stephen Kipp. It has been common practice for director building surveyors to issue compliance certificates to staff members within that company who are the RBS to satisfy Regulation 121. Can the panel comment on the good faith test in this case? Wayne, would you like to take Stephen's question? You're on mute, thanks.
Yeah, no, I'm right. Regulation 121, fire engineering designs. Look, I think historically there's been many issues that have been conducted within the office of a relevant building surveyor, whether it be the issuing of certificates under Regulation 121, or whether it's been the development of a performance solution and acceptance by another. I would hope that these practices are few and far between. I understand that once upon a time they were probably more common than what they are now. The good faith test, well, I think we've got to go back to what I mentioned earlier on, the difference between a relevant building surveyor and a consultant building surveyor, or many other professions, is that when acting in the capacity as a relevant building surveyor, you are the independent statutory decision maker. And I think historically we have learned, and this code of conduct reinforces what you can and cannot do and the expectations of the community as the independent statutory decision maker. And Stephen's probably sitting there absolutely squirming, saying, answer the question, will you? And I think it's pretty obvious, Stephen, that in that regard, whilst the relevant building surveyor may have thought that they were seeking some additional professional services and referring it to someone who may have known more than they did, I think it's pretty clear that it's not independent, and it really highlights the need for the independent peer review.
All right, we've come to the end of the session. Andrew, do you have any final words to close out?
Thanks, Bronwyn. Yeah, I'd just like to thank everyone for their attendance. I'd like to thank the panellists for a great session. I think there's been some great questions there, some food for thought on both sides, I think. So I'd just encourage you to continue having a look at the Code of Conduct, ask your questions. We're hoping to have a frequently asked questions site on our webpage, so a lot of these that may not have been answered and those that have been answered will hopefully find their way onto that website, and we're hoping that will be an evolving resource that will sort of depict some of the experiences that we're having and others are having in regards to interpreting the Code of Conduct. So I think I will encourage you to sort of keep up the discussion, and yeah, we're hoping that we can implement this as smoothly as possible over the next sort of 12 months. I think there may have been a question as to when this actually comes in. So it is gazetted for implementation as of 1 January, so becomes law as of then. But as suggested, we'll sort of have an introductory period. We'll continue some of the education. So I think there'll be more things that will be teased out as we move along that will indicate where our shortfall is in regards to understanding within the code. So we'd look at filling those gaps as we can moving forward. So once again, if there's areas of concern or lack of understanding, let us know, and we'll try and either provide stuff on our website or look at further presentations to address that. So to Peter and Wayne, thank you very much, and Bronwyn, much appreciated in hosting or emceeing the session. I really appreciate your expertise in this area in assisting not only with this presentation, but as we've gone along this journey. So thank you to you all.